Hi friends, in this video we are going to deal with the important judgment titled as RIPUDAMAN SINGH vs TIKKA MAHESHWAR pronounced on 6th July 2021. This judgment deals with that a compromise degree in respect of land which is not the subject matter of suit but is part of the settlement between the family members does not require compulsory registration. To know about the synopsis of the case, please watch the video fully. The facts of the case would be that RIPUDAMAN Singh, the appellant, filed a suit for possession disputing the will executed in favor of TIKKA MAHESHWAR to the respondent. The appellant claimed half share of the land as described in the plaint. During the pendency of suit, a decree was passed on the basis of compromise arrived at between the parties. In pursuance of the decree so passed, the plaintiff sought a mutation of the half share of the land vesting to him, which was allowed by the naib Tahsildar. However, an appeal against the said mutation was disposed of with the direction to naib Tahsildar to decide the mutation afresh, as the mutation was sanctioned without granting any opportunity of being heard to the respondent. The appeal filed before the divisional commissioner was dismissed on ground that the compromise degree in the absence of registration is against the provisions of the Registration Act 1908. After a long legal hustle, the appeal is before the Supreme Court. The issue discussed in this judgment is whether a compromise degree in respect of land which is not the subject matter of suit but is part of the settlement between the family members requires compulsory registration in terms of section 17(2)(6) of the Registration Act 1908. The Supreme Court has held that section 17(1) of the Registration Act 1908 provides the list of documents of which registration is compulsory. Section 17(2)(6) clarifies that this compulsory registration is not applicable to any decree or order of a court except a decree or order expressed to be made on a compromise and comprising immovable property other than that which is the subject matter of the suit or proceeding. The compromise degree entered into between the parties in respect of land which was not the subject matter of the suit is valid and is thus a legal settlement. It would be relevant to notice that the respondent has not disputed such settlement on any admissible grounds before any forum. An aggrieved person can seek enforcement of family settlement in a suit for declaration wherein the family members have some semblance of right in property or any pre-existing right in the property. The family members could enter into settlement during the pendency of the proceedings before the civil court as well. Such settlement would be binding within the members of the family. If a document is sought to be enforced which is not recognized by a decree, the provision of clause 5 of subsection 2 of section 17 of the Registration Act 1908 would be applicable. However, where the decree has been passed in respect of family property, clause 6 of subsection 2 of section 17 of the Registration Act 1908 would be applicable. The principle is based on the fact that family settlement only declares the rights which are already possessed by the parties. Further, in view of the enunciation of law in Poob Singh versus Ram Singh Major and others, reported in 1995 5 SCC 709, the judgment and decree of the High Court holding that the decree requires compulsory registration is erroneous in law. The compromise was between the two brothers consequent to death of their father, and no right was being created in presently for first time, thus not requiring compulsory registration. Friends, to conclude, in this video we have seen that a compromise decree in respect of land which is not the subject matter of suit but is part of the settlement between the family members, does not require compulsory registration as per RIPUDAMAN SINGH versus TIKKA Maheshwar case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.